don't have to tell you things are bad. Everybody knows things are bad. Everybody's out of work or scared of losing their job. The dollar buys a nickel's worth. Banks are going bust. Shopkeepers keep a gun under the counter. Punks are running wild in the street, and there's nobody anywhere who seems to know what to do, and there's no end to it. The air is unfit to breathe, and our food is unfit to eat. And we sit watching our TVs while some local newscaster tells us that today we had 15 homicides and 63 violent crimes, as if that's the way it's supposed to be. We know things are bad, worse than bad. It's like everything everywhere is going crazy, so we don't go out anymore. We sit in the house, and slowly the world we're living in is getting smaller, and all we say is, please, at least leave us alone in our living rooms. Let me have my toaster and my TV and my steel-belted radios, and I won't say anything. Just leave us alone. Well, I'm not going to leave you alone. I want you to get mad. I don't want you to protest. I don't want you to riot. I don't want you to write to your congressman because I wouldn't know what to tell you to write. I don't know what to do about the depression and the inflation and the Russians and the crime in the street. All I know is that first, you've got to get mad. You've got to say, I'm a human being. God damn it. My life has value. So, I want you to get up now. I want all of you to get up out of your chairs. I want you to get up right now and go to the window, open it, and stick your head out and yell, I'm as mad as hell, and I'm not going to take this anymore.
Hey, hello there, ladies and gentlemen, and welcome to this 272nd episode of the Political Spotlight. And this is the episode where, ladies and gentlemen, I tell you, I'm never going to get a haircut again. No, seriously. It is about 6 weeks out of control. I just about today lost it. I had a headache this morning, and it was just a day where my hair was like literally hurting my head. And I was like, man, if I could go get a haircut right now, I would. So tomorrow, ladies and gentlemen, just might be the day. Time will tell. I don't know. Welcome, ladies and gentlemen. This episode is called Our Reply to Their Reply to Our Filing. And for those of you that have been in just major withdrawal for Sproles coverage, ladies and gentlemen, I can announce that we are under officially a Sproles Watch. Sproles Watch 2024 continues. This episode will be an episode where we are covering the Sproles lawsuit, my lawsuit with John Sproles, and we'll cover all news, Sproles news, anything related to Henry County, the Sheriff's Department, John Sproles. We will cover it. The majority of this episode will cover a filing, and we'll get into that in a moment. I'll talk to you all about that. But we are in a point right here where we're going to be having some Sproles news over the next couple of days, maybe, and or weeks. As I'm looking ahead on the horizon, I think that some things are going to be happening. Some things are going to be being done. Some movements going to be being made where we might be having some more Sproles news over the next couple coming days and weeks. So stay tuned, my friends from Henry County and those beyond that care about what's happening in Sproles country. For everybody else that's out there, welcome. Well, for everybody in Henry County and the cares, welcome to you guys too. We do have a little bit of housekeeping to take care of right here at the beginning of the show. I talked to my dear friend in the battles and in the throes of a campaign today. I talked to my dear friend Donald Rainwater. Rainwater said that he was on his way to do an interview with a radio program from up in northern Indiana. And I literally now I knew the two guys that he was going to interview with, but literally as I'm sitting here, my early onset dementia is making it not come to my mind, and I just literally can't think of who it was. But as soon as it wasn't going to be a live interview, so it was an interview that they were doing today, and it would be released like tomorrow or sometime soon. So as soon as that releases, we will put that out for people to listen to. I also am in the stages of talking with Micah Beckwith about having Beckwith back on the show to maybe try and hammer out some of these questions, these questionable questions that have come up as of late. So we're in the process of doing that. I am in the process of talking to Braun's people about trying to get Braun on for a few minutes just to kind of go over what he's talking about, letting people hear, you know, this is where we stand, what's happening. That's going on. It got brought to my attention, interestingly enough, today, and we're also going to go over this maybe coming up here, that Michael Hicks is pretty squarely in McCormick's camp, which is really odd for a man who claims to be, you know, claims to be a Republican, conservative Republican. It's just interesting to me to see all of the people that are not backing Braun, which, look, I'm okay with. I'm okay with that. You know what I mean? It's just interesting. So we're going to be taking a look at that. No, Joe Black, you have to tell them they have the right to speak up. Please speak up. Quit waving your hands. The guy, I arrested a mime one time, and there was a fly in back, and he was trying to get the fly out, and I turned around and I said, "Watch your hands." You know, you wouldn't tell a mime to watch their mouth. You would tell their hands to watch you'd tell a mime to watch their hands. And anyways, I messed that joke up. Whatever. Anyways, so the first thing that I want to make sure that folks are aware of, tomorrow morning at 9 a.m., this is for the people who are watching live, we are talking Thursday, August 29th at 9 a.m. There is a Madison County Election Board meeting. Now, they tried their level best to make this fly under the radar situation and to put up the notice but not tell anybody. Matter of fact, they didn't even tell the person who spurred this on. And I know that she wants to come on. I didn't think it would make sense to have her on beforehand. So tomorrow, ladies and gentlemen, after the 9 a.m. election board meeting, we will more than likely have Dr. Catherine Callahan on tomorrow evening. And I've got a little present for her when she comes on. And it's a present for her and a present for everybody else. It's kind of like a win-win situation. It's something good for all of us. So I'm gonna hold that off till she's here. But we'll probably have her on so we can break down what happens tomorrow morning. So that'll be tomorrow morning for all of you that are watching this live. That'll be tomorrow morning, Thursday, August 29th, 2024 at 9 a.m. For all of you watching this in the future, well, it's already happened, and you could probably even go and watch our breakdown video. So check that out as well. Besides that, also coming up of importance, we've got Labor Day weekend popping up. So next week's going to be kind of screwy. Next week's the first of the month, but we basically won't have any council meetings on Monday because it's a holiday. I don't really know how some of the county governments are going to do their commissioners meetings. I don't know if they're going to do them on Tuesday or if they're going to kick them to the next week or if they'll just choose to have one meeting this month instead of two. So there's multiple ways they can do it. We will keep you up to date on all of that. Also, coming up in real quick order on the 12th, that's just like a week and a half away, basically. The 12th of September, we will have our second of 3 town hall forums with the man, the myth, the legend, Donald Rainwater. He will be, of course, part of our production. It'll be his event. We will just be producing it and moderating it for him. This will be a Donald Rainwater Town Hall event, virtual question and answer session starting at 7 p.m. Eastern, and it'll run for about an hour on the dot on Thursday, September 12th, 2024. You can tune in to watch and interact live. You can find the link. It's already set up, Rainwater Town Hall 091224. Obviously, that's the date. You can go there and leave questions in the live chat. The live chat is open now. People can go and comment and talk there as much as you want. Or you can obviously submit questions. Kate's put it up there on the screen a couple of times. Submit questions to the Rainwater Town Hall event at the following link, and that is at www.rainwaterforindiana.com/contact. Go there and leave your questions, leave your comments. We will then have a third event after that in October. We'll worry about that as it gets closer. Then beyond that, we will obviously have a Muncie City Council meeting. This is going to be a big meeting. Do they have the budget in? Are they going to start working on the budget? What's going on there? I have some very serious news that we will be talking about in the way of some record requests and some dealings with Muncie. There's just an awful lot going on right now. Eric Manning saying, welcome, Eric. Eric is saying the Newcastle City Council meeting is moved until Tuesday the 3rd at 6:30 due to Labor Day. That's good to know. So see, a lot of places do that. Then a lot of places bump it to the week after. Some places just say, the hell with it. We'll do it, in the 3rd of the month. So we'll just see what happens. That's interesting to know that about Newcastle. I did not know that. So I appreciate you giving me that information. So we'll be following all of this and seeing what's going on. So I think that's covered all of our housekeeping. Oh, while we are at it, we might as well say, of course, we are broadcasting this to you live on Wednesday, the 28th of August. And that means we are 240 days into this communication dry spell between myself and Muncie City Councilor Dale Basham. He refuses to answer questions through text, through email, through Facebook Messenger, through phone call. He just refuses to speak to the public. And while I'm sure that there are people out there that he corresponds with, like I know, for example, he corresponds with Mayor Dan Ridenour. No harm, no foul, no problem. I'm sure he picks up the phone for Lori, Corey, Finsey, Kinsey, Lindsay, Bink, whatever her name is. Lindsay, Corey, Bory, Bink. What I keep forgetting it. Fink. I'm sure he picks up the phone for some of those people. However, he didn't run as I'm going to be a counselor for like 4 different people out there. He ran to be a Muncie City Councilor, and he ran to be a representative of all people within the city and without the city. The people come in and do commerce and pass through and buy. And so it's really sad. It's really disgusting. It's really, it's something that we need to start really taking a look at what we're going to accept and what we're not going to accept. So we need to deal with this. So episode, this is the 272nd episode. It's being broadcast on Wednesday, the 28th of August, 240. Man, I'm going to say, realistically, it's probably a lot longer with Jessica. I just haven't been counting. I specifically counted with Basham, and the reason it's really been an issue with Basham is because when he announced that he was running last year, Basham announced that he was running when he first announced to be a candidate for city council, he said something just completely crazy and off the wall. He said, "I am running to be a voice and a vote for the mayor." He did not say, I am running to be a voice for the citizens. I'm running to be a vote for the citizens for what's best for the city of Muncie. He said, "I am voting to be a voice and a vote for the mayor." Matter of fact, over the break this weekend, I will locate that video and audio so we can start putting it out there. So when I say this, people can see it, because it's very important. It was very crazy. It touched me back then. I was like, whoa, this is nuts. You know, this guy needs to not win. Unfortunately, he did. It is what it is. Troy, in my opinion, Troy Ingram should have won over Basham. But you know, we are where we're at. So that's the deal. The citizens of Muncie elected Basham, unfortunately, and elections have consequences. Of course, we're seeing that everywhere. So 240 days, no correspondence with Dale. That's sad. It is what it is. Hey, we are here. We're getting ready to get into the craziness of the episode. I want to thank you all for being here and watching. For those of you that are here on Facebook, Twitter, TikTok, whatever, thank you, thank you, thank you. I appreciate you watching from wherever you watch from. We're grateful for that. I do say so. I mean, look, it helps us out. I'm not gonna lie. It helps us out if you watch us from YouTube. If you watch from YouTube, it helps us out. It doesn't cost you anything, but it helps us out. The one plus it offers you is if you're someone that communicates with us and comments in the live chat box over here, it gives you a larger audience to communicate with. There's more people to be able to talk with. Okay. So that's that. But beyond that, we thank you and we welcome you wherever. If you're here via YouTube, we would ask that you do these things over here on the side. Click the thumb, hit the bell, communicate with us, and above all else, please, please, please share the show with everyone you know. All right, so let's get into the episode, ladies and gentlemen. So, for those that have been watching and watch fairly religiously and continue to watch, routinely throughout the nights, you will know. But for those that might tune in and out when we cover different things, this is technically one of 3 episodes so far. There've been 3 episodes. When I first did this, I knew that there would be 1. I knew there would be 2. But I didn't know that there would be more. So this is kind of the 3rd episode in a series. I have put the other 2 episodes, the links to those episodes, in the description of this video on YouTube. So for those that want to watch the other 2 episodes, you can clearly jump on. So the description to this episode reads, this is the 272nd episode, and it looks at the legal response from host Kristopher H. Bilbrey's side in the federal civil rights violation lawsuit against Henry County, Indiana Sheriff John M. Sproles. This is the 3rd video covering similar information. The first video, which was episode 237, looked at Bilbrey's memorandum of law in support of plaintiff's motion for partial summary judgment, which was filed by Bilbrey's attorney, Gavin M. Okay. The second video in this series was episode 254. The second video was 254. The second video, episode 254, was then Sheriff Sproles' legal filing in response to my filing. So for those of you that recall, we went through my filing. We then went through the sheriff's filing. This 3rd episode will take a look at my reply to that filing of the sheriff's. From here, where do we go? Well, it's not like something where we just keep, we poke him in the eye, then he pokes us in the eye, then we pull his hair, then we bite his finger. It has an end eventually. So we made a filing. The sheriff's team then made a filing. This is our response to the filing. They now have, from yesterday, 14 days for a reply. At the end of that 14-day window, they can either reply or not reply. It'll be interesting to see what they do. I could almost about half expect them to not issue a final filing. That will be very telling if they don't. They have 14 days in which they can issue the final filing. At the end of that 14 days, it will be in the judge's hands to decide if a summary judgment will be awarded either in my way or his way. So that'll be interesting. Now, we are only asking for a partial summary because, to me, this is about the First Amendment rights. And it's not just my fight, folks. It's not just a fight for my First Amendment rights. It's not just a fight for everyone else in Henry County or specifically in Indiana's rights. However, this is a fight for the rights of everyone in the United States of America. This is a big deal. This is a really big deal. There are not a whole lot of cases that have been forward on social media. First Amendment rights have lots and lots and lots of case law attached to it. And while we have had social media and the whole online environment for quite some time now, in the eyes of the court, it's still fresh. It's still new. And so this is pretty ripe for case law to be made and for decisions to be made. So, it's definitely, an interesting look at what's going on, because from where I sit, I feel like we have a very good and strong case. And I feel like my legal team is committed. I think that they feel strongly about where we are with our case and what our chances are. However, I've announced this from the beginning. I feel like they're pretty committed that if the worst case scenario happened and something happened to go wrong, and we for some unknown reason did not come out victorious, I do feel like they are prepared to challenge that and to appeal any loss, which, hey, I've got no problem. Let's take this on up to the Supreme Court. I'll fight him all the way, wherever, any day, anytime, wherever he wants to go, there I will be. So I'm ready to rock and roll, because I believe strongly in what we're doing here, and I believe that that this is important. Okay, so this is an important question. Timing Issue says, how much cash do you have wrapped up in this goofball? Care to share? So, it is true in this case, because it's a First Amendment rights lawsuit, that the ACLU is representing me. So I have $0 in this. This is the first. I've been involved in some lawsuits. There are two types of lawsuits, basically. Well, there are several types of lawsuits. There are two avenues that one can go down. You can go down a state suit, where it would be in a circuit court or superior court, and we would go before that judge, and it would be a state case. Or you can do a federal lawsuit. The couple of examples that I have dealing with things like this have all been in federal court. And I will tell you that when you have a 1983 suit, which is a civil rights lawsuit, say, for example, you're arrested with, without cause, or the police seize your property, or they jail you, they take your liberty, or they injure you, or some other, if a politician does something against your First Amendment rights, or your civil rights as a human, if it's 19 as an American, it's a 1983 suit. Generally speaking, when an attorney takes you on in that case, you don't have a lot of money in it up front. Basically, what happens is, if there is money in the case, they basically do it, on the thought that when you win, they will then take like a third or 33% of your winnings. That's to know. Now, I will tell you, don't go into that thinking I'm going to be in this with no money out, period, because you generally have to pay for the filing, and you generally do have to put some money up front for your attorneys, like, maybe some like gas running to and from, and paperwork. So, for example, in my lawsuit with Winchester, up front, I paid about $5,000 out. I didn't pay that all at once. I paid $450 for the filing, and then I paid like $1,200, and then I paid like another $1,200, and I think we got to about $5,000. At the end of the day, when I received a check, that lawyer then took 30% of that minus the $5,000 that I had paid, not including the $450. The $450 was out of my pocket, the filing fee. So that's basically what happens. That's basically what happens there in a lot of cases. Now, if you're in a situation where the ACLU takes you on, basically I pay for nothing, and then they take, a portion of their filings, a portion of their, and all they're looking for at that point is just their time, and they're not getting paid out of any winnings that could be there. They're just at that point looking for lawyer fees for the time that they're doing that. So that, ladies and gentlemen, is kind of an early rundown on that, kind of a not an early, kind of a behind the scenes look, I guess, is what I was trying to say. So without further ado, let's go ahead and pop this up. And it's kind of a shame, because I think it's best to see these things. It's best to see these things compared to one another. However, as we're reading through the filing, I feel like you will get an understanding of where we're at. For anybody that remembered, basically, to kind of, while I'm waiting for this to load, our originally filing was like 39 pages, 40, maybe 40, 42 pages, something like that. It was a pretty massive filing. And I went over with you the fact that I've been in and around the legal system for some time. I have interacted with a lot of different attorneys. I've seen good filings from lots of attorneys, and I've seen a lot of I've been around a lot of good attorneys. I've been around a lot of bad attorneys too, and I've seen excellent work from people in trial, and people who are good at debate, people who are good at questioning, people who are good at writing legal briefs. I have never in my life, never, this is the first time ever seen, I've just never witnessed an attorney write the way that my current attorney writes. I really give him a lot of props. He is masterful with the pen, and just as masterful as he is with the pen, he is in court while talking to the judge, talking to the other side. This man, Gavin Rose, I tell you what, if it wasn't a crime, I would show up to his work one day. I would kidnap him, and I would bring him to my studio, my house, and he would just live with me and do work for me because he's the best attorney I've ever seen. It would be kind of like a Misery situation. He's just going to be driving one day, and then all of a sudden he's going to wake up and he's going to be like in a hospital bed while I'm standing there with a sledgehammer and being like, all right, I can't wait to read your next legal brief. No, I'm serious. Like this dude, I look at him. He is definitely a friend. I mean, I count him as a friend. He's probably like, what? Get this freak away from me. But I look at this man he is a brilliant mind, and I'm extremely, extremely happy with this man as an attorney. So he doesn't have the ability to do any work privately. He only does work as the ACLU. So if you ever have a chance to have an ACLU suit, I hope you get this man.
When you are reading a legal brief,
yeah,
and it makes you laugh.
Yes.
It's just a priceless moment.
Yeah.
Legal briefs are boring as hell.
Yeah. It's very dry.
This makes me laugh.
Yeah.
On multiple occasions, I actually laughed out loud. Reading this brief. And laughed every time I read it after that, because I went through it like 5 times.
Yes. Yeah. Stay here for a second. So the thing is, and I don't feel like it's appropriate. Like, this is public record. What we're getting ready to go over is public record. And I don't think it's appropriate to actually say the words because it's technically wording between my attorney and myself. Kate was aware of it because I sent the thing to her and we talked about it. But I'm not going to say exactly what he said. But do you remember the thing that I told you when he messaged and he said that thing when he was asking that question that he was looking at? And he was trying to do was determining what their side was getting at. Remember when I told you that?
Oh, yes.
Okay.
Yes.
Even in reading an email that he sent to me as just a short email when just talking about the situation made both of us kind of chuckle, because we're like, damn, this guy gets Sproles the way that we get Sproles. And it's really just amazing. So this guy is truly amazing. But Kate is spot on.
He has a very dry and sarcastic sense of humor.
Yeah.
And his personality comes through in writing a legal brief.
Yeah.
It's absolutely brilliant.
Yeah.
And it just nitpicks.
Yes.
It's just this thing of beauty. You guys are going to love.
I will say
it's just amazing.
Gavin is the best little, like sarcastic, kind of like witty, bitchy, like little guy. That he's just the brilliant legal mind, and it's truly amazing. And she's exactly right. You guys obviously don't know him. Brandon has dealt with him with an issue, and we all she's never met him, but you can tell his personality. She's 100% right. You can tell his personality throughout his writing, and it's totally magnificent. So yeah, I think it's great. So I think without further ado, we have talked this dude up, and we can read through this. Yes. The Mayor 765. That's 100% accurate. And basically what happened, it's not the county's insurance. You're technically you're right and wrong. It's even worse than that. It's the attorney for the insurance company that dropped the county. So, yeah, Bilbrey's about to get a message saying, I think all of our meetings should be done via Zoom. Yeah, right. Yeah, right. That's hilarious. No, I love Gavin. He's amazing. But yeah, so no, that is a very important thing, because number one, generally when you want your attorney to be on your side. You want your attorney to at least, man, think about how many people walked into an attorney and lied about the reason they're there. Defense attorneys happens all the time. Divorce attorneys, that stuff happens all the time. Attorneys, I think, are used to working for people that they don't specifically maybe believe in the back of their mind, which is fine, I guess, but they have to be able to at least present the legal argument for why they should be treated fairly. A lot of people are like, I don't know how you would represent a murderer, or how you would represent, someone who was a sexual predator. I just couldn't do that. And at the end of the day, first of all, our legal system is such that someone has to do it. And second of all, it's not about representing the actions of the individual. It's more about making sure that shit's done right, and that the legal system works the way that it's supposed to do. And so, the record is preserved, and that they get a fair trial per the rights guaranteed to all of us. So that is important. That being said, in Sproles' situation, he's being represented by somebody that dropped them. And the reason they dropped the county is because they thought that Sproles was out of control. They dropped him because they thought he was nuts. Jack, you idiot. That's hilarious. All right, ladies and gentlemen, here we go. Without further ado. All right. Let me see how we want to do this. Oh, no, I don't want to do it this way. I forget. When we do this, I want to... Oh, no, I think I can make you see this. Yeah, can you see that? That's viewable. Okay, we're good that way. Okay, so, and for those of you, even if you don't go back and listen, I would highly recommend, for anyone that has not saw our first video on this or the second video, like I said, it's episode 237 and episode 254. I would highly recommend going back and watching them, so you get my attorney's first, their filing versus Sproles' attorney. Sproles' attorney, just reading his, they do not like him. I feel like they do not like him as an individual. Okay, so this starts out, obviously, it's United States District Court, Southern Division. Our cause number, it's Bilbrey versus Sproles. Now, this is the legal title of this is Plaintiff's Reply in support of his motion for partial summary judgment and response in opposition to the defendant's cross motion for summary judgment. Okay. And so, again, it lays out the table of contents. And this is where we get the beauty of what we're going to hear in this piece. All right. So we've got an introduction, issues concerning the facts. We're going to hear pieces on the sheriff's evidentiary objections being without merit. And this case does not hinge on any disputed material facts. So the material facts that we've laid out, they don't dispute. They don't dispute the material facts that we've laid out. And what hinges on whether this case goes in my favor or not, it does not hinge on any disputed material. All right, that's important. All right. The sheriff's voluminous objections to Mr. Bilbrey's affidavit are without merit. So the number one thing, and we're going to hear his thoughts on this, the number one thing that anybody that read the sheriff's filing is his, like, because my attorney's was like 39 like pages or something like that, somewhere around in there. I think theirs was like 19 or 20. It was definitely shorter, but the entirety of the document wasn't about why they didn't do this, why the sheriff didn't do this. It was about it was about objecting to me as a human being. I shouldn't be saying this. How dare I question this? I don't have a right to say this or say that. Just crazy things, okay, first and foremost. All right? So I love how he puts that out. The sheriff's voluminous objection to Mr. Bilbrey's affidavit are without merit. They have nothing to do with this. The sheriff's elaboration on several facts previously articulated by Mr. Bilbrey does not create a factual dispute, and he does not contend to the contrary. Despite the sheriff's criticism of Mr. Bilbrey's political commentary, this commentary is both fully protected by the First Amendment and largely irrelevant to the litigation. Whether I think Sproles is a cockwomble, or whether I think he's an idiot, or whether I think that he and his sister have a bizarre relationship and she should stay the hell out of his political affairs, all right, that's got nothing to do with whether or not Sproles violated mine and many other citizens' rights, which is what the case is about. But they wanted to make it about all of these other things. Kate said it best. I'm saying Sproles violated my rights. And Sproles is saying he's a bad person. He's a meanie. He's a poo-poo head. That is what our legal arguments are coming down to. I am saying he violated my rights. Here's how and why. And he's not saying, no, I didn't, or this is why I did. He's saying Bilbrey bad. And that's not how you win a lawsuit. Also, by the way, for the majority of this reading, I will be off of the screen on the other screen. I don't know who that is. Nakamoto. Welcome to the show, Nakamoto. So that's hilarious. Kate's having a conniption. Yeah, Sproles is operating from feelings, not law. That's very true. So just as a standard, Kate, if there's anything I need to hear, or you just pop in, because I will be off screen, so I will not be seeing most of your comments. I will go back afterwards and look at your comments. Kate will be looking them up. Kate will be responding if and when necessary. And if she needs to stop me for something, she can stop me, but I will be. I
was going to make you come back because I know you're off screen to see the Nakamoto comment, but I couldn't stop laughing to breathe enough to be able to click a button. So.
I'm glad I came back in enough time to see that. That
about broke me.
I love it. All right. So moving on. Although the merits of this litigation do not hinge on factual disputes, portions of the sheriff's statement of undisputed material facts require elaboration. All right, that's important. Facts concerning the operation of the separate Facebook page maintained by the sheriff office are at best of only tangential significance to this cause. The sheriff's description and use of his Facebook page at issue in this litigation requires significant elaboration, and the broad generalizations that he makes concerning his use of the page are not supported by the record. Number 16, argument. The Sheriff Sproles' operation of the Facebook page at issue in this litigation and his blocking of Mr. Bilbrey from the page constitute state action for which he may be held liable under 42 U.S.C. 1983. At all times since assuming office, the sheriff has possessed actual authority to speak on behalf of the Henry County Sheriff's Office with respect to the issues about which he routinely posts on Facebook page at issue in this litigation. The sheriff purports to exercise his government authority through Facebook page at issue in this litigation. By blocking Mr. Bilbrey from Facebook page at issue in this litigation, the sheriff has prevented him from viewing or commenting on some posts made directly to the separate sheriff's office page through which he acknowledges that he exercised official authority. All right. Before the sheriff added the disclaimer to his Facebook page in July of 2023 and changed the name of that page in October of 2023, there was no ambiguity with respect to whether he exercised governmental authority through that page. He clearly did, period. The Facebook page at issue in this litigation remained a governmental page even after the sheriff added the disclaimer indicating that it was not an official page. That's like, I don't know. Me shooting you with a gun, me shooting a gun at you and missing, and then saying, oh, by the way, this isn't a gun, and then shooting you again and hitting you, and then putting a sticker on the gun that says not a gun, it's a toy. I've still shot you. You know, you can say what you want after the fact. It doesn't change what the reality of the situation is. Insofar as the sheriff's administration Facebook page is at issue in this litigation constitutes state action, the blocking of Mr. Bilbrey violates the First Amendment. And then he lays out a conclusion. Okay, so then we go on here, and this is the first part. Introduction. In opposing Bilbrey's summary judgment request, Sheriff Sproles expends an inordinate amount of energy contesting Bilbrey's factual recitation without actually articulating any facts that he believes to be in dispute. So right here, my attorney is saying they blabber on about a whole bunch of nonsense that has nothing to do with anything, and they lay out no factual issues actually articulating, you know, what he believes to be in dispute. They don't disagree with largely anything that I say. There are no such facts. The sheriff posts to the Facebook page at issue in this litigation, and his other uses of that page are incontrovertible. And this evidence demonstrates that upon assuming office at the beginning of 2023, the sheriff repurposed a Facebook page that had previously belonged to his political campaign and transformed that page into the official government page of the Henry County Sheriff. I mean, ladies and gentlemen, I think Gavin could have stopped there. Gavin could have typed up those 3 sentences and said, all right, Your Honor, that's it. Like, I love what Gavin has done with this entire document and all of his other work. I love it. But I kind of wish he would have done something like that, because I truly believe that the judge is intelligent. And I mean, most people that reach positions like that have some kind of intelligence about them. But having listened to and seen this judge in our other actions throughout this litigation, I find him to be a very competent and intelligent man. And I think that my attorney could have easily dropped these 3 sentences and said, introduction, conclusion, you know, have a nice day. And the judge would have been like, yeah, you're right. Okay, so that's important. This is basically all you need to know. Everything else is just fun. Among other things, it is clear from his decision to retitle the page. So keep in mind that he titled it from John M. Sproles for Henry County Sheriff, the name of the political page, to John M. Sproles, Henry County Sheriff, the name of a governmental official. All right, so that's what he did. The manner in which he has admittedly, repeatedly utilized the page to perform official functions, such as soliciting artwork for the Henry County Sheriff's Office and addressing a variety of constitutional concerns. His consistent use of the page while on duty for the Sheriff's Office, and his utilization of the page to share footage from his own body-worn camera, an act that, under Indiana law, belongs exclusively to the Sheriff's Office itself and not to a political campaign. In other words, the nomenclature that the sheriff has assigned to the page on summary judgment, Sproles for Sheriff, is simply not borne out by the facts of this case. Just, you know, you can put lipstick on a pig, that whole thing, you know. Under Linkey versus Freed, which was the Supreme Court, one of the Supreme Court cases that just came out in February of this year, that has a ruling that relates to this case. Under Linkey versus Freed, to determine whether the sheriff's operation of the page at issue in this litigation constitutes state action, the court must assess whether Sheriff Sproles has actual authority under state law to speak about the matters that he routinely posts to the page, and whether he purported to exercise his authority in doing so. So while you guys are not lawyers, you guys are not the judge, let me just ask you this question. Just tell yourself this in your head. Do you believe that an elected official, in this case the sheriff, do you believe that that official has the authority under state law to speak about matters pertaining to the office in which that elected official holds, be it the mayor, be it a counselor, be it the sheriff? Do you think that they can speak about matters relating to being the sheriff, being the mayor, being a counselor on a page which is created under the title so-and-so elected mayor, John Doe city councilor, Muncie Mayor Dan Ridenour, Henry County Sheriff John M. Sproles, John M. Sproles, Henry County Sheriff? Do you believe that they have the actual authority to speak on that page? I mean, unless you just can't understand English, the answer is yes, they have that authority to do so.
Well, that and if they've titled it, you know,
yeah,
John Smith, Washington County Sheriff, and they're posting about it, then I might even make the assumption that they are in that position.
Sure, absolutely. So, yeah,
specific. The two kind of go together. Not only do you have the authority to speak, but because you have the authority to speak, I assume you have a position of authority.
Yeah, you are that person. So absolutely. So
it kind of goes back and forth between the two.
Yeah, sure. That's a very good point. And so that's, you know, for the sheriff to be like, well, I am the sheriff, you know, because John Sproles isn't, you know, John Doe, he is John Sproles. And because he is talking and he was elected to be the sheriff, and this page did say, and he only changed it after we sued him. Keep that in mind. You know, obviously that it's just nuts that they would say differently. The sheriff's contention that he has lacked actual authority to speak about activities and prerogatives of his office sorely misconstrues Linkey, as well as state action required in general. And his contention that he has not exercised that authority through the page at issue in this litigation runs headfirst into the actual facts of this case. Listen, this is the nicest way. This is the nicest way for my attorney to say John Sproles has lied. I mean, that's the nicest way to be like, he's clearly lying. Now, I'm not going to speak for my attorney in that fact, because my attorney is a much nicer person than I am. So maybe he just means that, seriously, he ran headlong into the facts of the case. Maybe that's what he meant. But to me, that's how I interpret that. Given that he does not routinely exercise his government authority, given that he does routinely exercise his government authority through the page, and under Linkey, the United States Supreme Court held under Linkey that myself or that Linkey or that any other person in this situation need to only demonstrate that a single post constituted state action. So, as long as the sheriff has at one time since January 1st, 2023, used his authority to communicate on that page with state action, and then he has blocked me, that's a problem. The blocking of Mr. Bilbrey from the page represents a classic prior restraint under the First Amendment that is subject to and fails strict scrutiny. All right? He goes on to say that I'm obviously entitled to judgment as a matter of law on liability and to permanent injunction requiring that he be promptly unblocked from the Facebook page at issue in this litigation. On the other hand, Sheriff Sproles' summary judgment motion must be denied. So ours must go forth, Sproles must be denied, and the amount of any damages must await trial. All right. Issues concerning the fact the sheriff's evidentiary objections are without merit, and this case does not hinge on disputed material facts. This case is not factually complex, obviously, for it hinges almost entirely on the sheriff's use of the page at issue in the litigation. The post of the sheriff is made to the page, since assuming the office are in the record and their authenticity is not in doubt. Nobody is claiming that I have faked pages, and it's, the sheriff's not saying, well, I really didn't do that. He's not doing that. He's claiming, yes, these are my pages. I'm claiming, yes, these are his pages, and it is what it is. Okay, that's what goes on there. Nonetheless, the sheriff begins his summary judgment response with a lengthy contention that this case turns on the factual disputes. In doing so, however, he does not actually articulate any such disputes, and it appears that he instead simply wishes to provide some elaboration on the facts articulated by Mr. Bilbrey. Again, that's where we run into the, don't look over here, look at the fact that Mr. Bilbrey called me a bad name one time. Okay? This does not create a disputed issue capable of defeating Mr. Bilbrey's summary judgment request. Nonetheless, it is necessary to address some of the details the sheriff is saying. The sheriff begins his response to Mr. Bilbrey's factual recitation of the by objecting to the admissibility of numerous statements to which Mr. Bilbrey attested. His objections are largely cursory, and even if meritorious, would not affect the propriety of summary judgment in Mr. Bilbrey's favor. First, in describing his interest in local, state, and national affairs, and his desire to voice his opinions on the issue, Mr. Bilbrey explains that it is his belief that as a former law enforcement officer, he has a perspective on issues concerning criminal justice that not every person possesses, and that he often seeks to add his voice to any debates concerning these issues. The sheriff objects to these statements as inadmissible speculation and unsupported bravado. That, again, is what I went over and said, listen, obviously, I have an idea of what happens when a dentist fills a cavity. I could talk to you about the processes that I think I know in my head. Being said that, though, since I am not a dentist and I have not been through dental school and I have never filled a cavity, I can't specifically talk to you piece by piece by piece and tell you what to do to lay out how to repair a tooth that needs filling. All right. I can tell you what it would be like to be a preacher because I have a belief in religion. I'm a Christian. I've been and seen preachers, but I am not a preacher. So, well, I guess I'm not. I'm kind of. But I've not been there. I'm not an auto mechanic. I've never flown a jet airplane, and I can talk to you about these things. But I can't talk to you about these things as if someone who was in the same context as if someone that was a jet pilot. Okay. I have been a police officer in various different settings, and I know that upsets Sproles, and I know he doesn't like it. I know it's like boo-hoo, boo-hoo. But facts are facts, and I do have an opinion on this that Kate doesn't have. Kate can probably get pretty close to various aspects of what law enforcement is like. And you can watch TV and you can read books and you can watch documentaries and you can have an understanding. But I just, unless you are completely from Mars, everyone is aware that until you've actually walked the walk, you don't have the same interpretation of it that, say, I would. So it's crazy that they would even say this. That being said, I could be completely cuckoo for Cocoa Puffs, and the First Amendment allows for that. The First Amendment does not require an individual to demonstrate a certain level of expertise before voicing their opinion. Therein lies the whole point of the internet, of Reddit, of comments, where you will see someone commenting on Neil Peart drumming, and they'll be like, "Oh, I could do it better than that. I played drums, and I was drumming at the Whiskey a Go Go, in 1960." And everybody's full of shit. They still have a right to say it. So maybe it is some form of speculation and unsupported bravado. I think that's wholly ignorant that they would even remotely try to stretch and say that, unless they didn't depose me. So maybe they don't know what my history is, or my history isn't, that could very well be. That was a misstep on their part, I think. That being said, the First Amendment protects me saying that. This is not something that would be outside of the First Amendment. This case does not hinge on whether Bilbrey has a right or wrong about any particular debate in the criminal justice community. So I could be completely wrong in everything I'm saying. It doesn't give him a right to block me, and it doesn't make me wrong about saying, hey, I've been wronged because I've been blocked. Bottom line. Rather, his background is offered to explain why he decided to access and comment on Facebook page at issue in this litigation. See, they're getting lost. It's like they're missing the trees for the forest kind of thing. All right. So the information that we offered in that first filing during that portion, it is admissible. Second, the sheriff takes issues with a wide array of statements that Mr. Bilbrey has made concerning the operations of the Facebook itself. And this killed me even more. This killed me even more than the law enforcement comment. Okay. So we talked about how Facebook works. All of us knows how Facebook works, even though none of us are engineers at Facebook. None of us are programmers and computer tech wizards, That being said, it's pretty common knowledge that many people rely on Facebook as a significant source of news. Now, you will note, we did not say that that is a good idea. We didn't say it was a good source. We didn't say it was the only source. We didn't say people should do it or people shouldn't do it. We just simply said, and I'm not even talking about news. I'm just talking about news and the fact that, hey, you might use Facebook to find out if your niece is pregnant. You might use Facebook to find out where your cousin's going on vacation. You might find out if your girlfriend's, prettier than your brother's girlfriend by looking at their pages, whatever. You use Facebook as a way to gain information on the world. We all know that. We also are all aware that there is an algorithm that Facebook has, and for whatever reason, it selects items to appear on a user's news feed for easy consumption. And that by following a person or a page that and interacting, it will allow you more than likely to see more of that page than, say, someone that you don't follow or you don't have any interaction with. We all know that. But they are saying, I don't have a right to talk about that I don't know how this works, and that it should not be admissible that I can say that. My attorney here lays out why that's completely nonsense. Okay? He goes on to say basically that the issue at litigation caused purports that the page well, let me back up here. The Facebook algorithm selects items to appear in a user's newsfeed for easy consumption. The fact that his act in following the Facebook page at issue in this litigation caused posts to that page to appear in my newsfeed, and the fact that the sheriff's action in blocking him caused the deletion of comments that I've previously made. That's just common sense. While the cursory nature of the sheriff's objections to these statements makes a response difficult, the facts are generally recounted from Bilbrey's personal experience as a Facebook user, and in fact are so rudimentary that they are likely amendable to judicial notice. Okay? So it's just ignorant that they would try to fight this. For instance, even though the sheriff quotes from these portions of Mr. Bilbrey's affidavit, it is not clear that he doubts Bilbrey's competence to testify to the fact that he relies on Facebook as a significant source of news. The fact that Facebook's news feed allows for easy consumption of information from a broad array of sources, the fact that following Facebook page at issue in this litigation ensured that posts to the page were likely to appear on Bilbrey's newsfeed, the fact that being blocked from this page resulted in the deletion of the comments that Bilbrey had previously made to the page, and the fact that before he was blocked, posts to the page frequently appeared in his newsfeed, while posts made it to the separate page maintained by the sheriff's office seldom, if ever, appear in his feed, or the ease with which officials may respond to comments on a Facebook page, the sheriff highlights the fact that Mr. Bilbrey has not been offered as an expert witness, but none of this requires expert testimony. Dude, it's nuts. It's offered from Bilbrey's personal experience as a Facebook user, and as noted, much of it is so rudimentary that the courts have concluded that similar information is noticeable, that I am allowed to testify on such, and that the judge can take my understanding as being factual in the fact that it's factual as a layman. All right, that as a layman, I can explain the basics of how Facebook works. I might not be able to explain it to my grandparents, but I can definitely explain it to the court. Okay. Notice of the fact that people can view a person's Facebook account or individual's posts subject to a person's privacy settings and sends a person a Facebook message without being Facebook friends with that person. There's just all sorts of things in there that he's saying that like people have an understanding of. All right. So we'll go on here. you know, he talks in the bottom notes down here that the help center that's online covers many of the items there. Okay. What does it mean to follow a profile? Content you can see from a blocked profile. Bilbrey's statement that many persons rely on Facebook as a significant source of news, whether or not deemed to be within his personal knowledge, is not subject to reasonable dispute. The Supreme Court itself has described social media websites as serving for many persons as the principal source for knowing current events, checking ads for employment, speaking and listening to the modern public square, and otherwise exploring the vast realms of human thought and knowledge. All right. And that's outlined in another case. All right. And he just gives a lot of those different examples. Okay. Let's see here. He goes on to say, like, obviously I don't know the exact working mechanisms of the Facebook algorithm. Okay. But the point made by Mr. Bilbrey is that whatever reason, before he was blocked from Facebook page at issue in the litigation, posts from that page routinely appeared in the news feed. For whatever reason, posts made to the separate page operated by the sheriff's office, which I did not follow because I was following the page that I knew Sproles was writing from on directly, they seldom appeared in my news feed. I don't know that they ever did because I didn't follow it. I followed the Henry County Sheriff John Sproles page. I interacted with him there. I never interacted with him on the other page. I only started following the other page when I was blocked by the other, and I noticed that I wasn't seeing a lot of other comments, and there weren't comments in there because he was copying from his other page. And because I was blocked, I was not permitted to see what he was sharing. These facts are based on Mr. Bilbrey's personal knowledge. I mean, this is so stupid that, like, I feel like my attorney feels stupid saying this. I feel stupid reading it. Like, you all know about it. Like, I almost feel bad that the sheriff, I don't know if this is the sheriff pushing this and the attorneys are like, okay, or if I don't know who's stupid here. Somebody is stupid. Third, the sheriff takes issue with Mr. Bilbrey's statement that after he was blocked from Facebook at issue, Facebook itself deleted Sheriff Sproles' post that he had misappropriated one of Bilbrey's videos. Whether or not Bilbrey is competent to attest to this fact, Sheriff Sproles himself testified in his deposition that he did receive notice from Facebook indicating that a complaint had been made about this post and that the post was removed by Facebook itself. Sproles made that statement. The sheriff objects to a fact that he acknowledges to be true. And if it wishes, this court may choose to rely on his own testimony. So screw my testimony, take my words out, listen to the sheriff. The sheriff said it happened. It's like this. It's like saying, hey, Sproles, what time is it? And he says, it's 10 after 7 in the morning. And I'm like, hey, it's 7:10. And sheriff's like, no, it's not. You don't have a right to say that. And I'm like, you just said it. Fourth, the sheriff objects to Mr. Bilbrey's statement that he has absolutely no idea why Sheriff Sproles decided to reference me in a series of Facebook posts. All right. Fourth, the sheriff objects to me saying that I have no idea why the sheriff would reference me in a series of Facebook posts. So the sheriff says that he objects to me saying that. This is objectionable, says the sheriff, because Mr. Bilbrey is not competent to speak to the sheriff's motivation in making a particular post. That's exactly what Bilbrey is saying. I have no idea. This is insane to me. I say, I have no idea why Sheriff Sproles decided to reference me in a series of Facebook posts. And the sheriff says, you can't say that because you don't know why I did that. Yeah, right. That's exactly what Bilbrey said. He acknowledged that he did not know why the sheriff referenced him in a Facebook page at issue in this litigation, but expressed his concern that he was being misleading by associating me with an individual who had been arrested for alleged child molestation, not even by the sheriff, and detailed his desire to set the record straight had he not been blocked. So, ladies and gentlemen, what this is in connection with, let me bring this down real quick. I want to get big and in your face for a second. What this is in connection with, this is in connection with that time that Sheriff Sproles was called to the Justice Center and dealt with Joshua Kimbrell. And they were arguing back and forth, and then Josh left because he was too afraid to go in, and that was that, and that was over. The sheriff did not go through the steps of getting a record release. He just went ahead and uploaded that. When he did, he was like, look here, poor me. This is what I have to deal with. Poor me, poor me. Look at this. Look at what I'm doing. Look at what I got to deal with. This guy's such a meanie poo-poo head. I got to deal with the likes of him and his friend Christopher Bilbrey. Look, this guy, heaven forbid, this guy just got arrested for child molestation. Birds of a feather flock together. So what he was doing there was he was trying to, in his world, tie me to Josh, an accused child molester, which, listen, no one's dumb. We obviously did work together for a time. We weren't working together at the time that was going down. We were still mutual acquaintances, but we didn't work on our channels together. We didn't hang out. We weren't at each other's homes. I wasn't involved with anything. I have no knowledge of the craziness that he was doing. I was the person who broke that story. I am most offended and most appalled by Joshua. I have worked as a sex crimes investigator for a number of cases, and it was absolutely appalling. Matter of fact, I almost left investigations and went back to patrol because of it, because I couldn't handle it anymore. That's where I went from there into narcotics. So screw Josh Kimbrell and the sheriff in the same boat for all of that. That is not something that I am okay with. It's not something that I talk about frequently, but I did not do well with the investigation of sex crimes. I was not something, I did well, but I wanted to bash people in, and it's not something that I was okay with. I have a very hard time with that. And so I almost gave up something that was a dream job to go back to uniform because I wanted to get out of it. I could not handle it. And so I lucked out and I was able to go into narcotics investigation. And that saved me. But, I have a major issue with that. And so, that's not something that I would have been a part of. I did not know that he was involved with that, and so, that's why I was, what I said was, I wasn't there. Sproles didn't interact with me. I wasn't involved. Sproles wasn't even involved with the arrest. Had nothing to do with Sproles. So I don't know why he was mentioning that. He went, and let me back this up. Let me back up and say this. When I say I have no idea why this asshole is tagging me in this, what I mean in that statement is I know exactly what that asshole is doing. And I don't like it, and he needs to stop it. That's what I meant by that statement. So I was saying, he needs to explain himself, because he's walking very dangerous to getting sued for defamation. Because what he doesn't seem to remember or understand is I can call his ass out. But I am just a lowly citizen, and he has to be careful what he says and does towards me, because it could very well be slander, defamation, libel, all of that good stuff. So that's what we were getting to. But, it's just comical what the sheriff, what the sheriff and his team either doesn't understand, or maybe they're throwing him to the wolves. I don't know. I don't know. Okay. Fifth, the sheriff objects to my statement saying that it's not uncommon for an elected official and the institution that he or she represents to operate separate governmental Facebook pages. A statement for which he provides 3 concrete examples with citations. While the sheriff initially objects to this statement as outside of Mr. Bilbrey's personal knowledge, again, this is stupid, lacking a foundation and constituting an inadmissible lay opinion, none of these objections has merit. This is a factual statement supported by specific examples based on Mr. Bilbrey's own experience as a Facebook user. Apparently recognizing that his other objections cannot carry the day, the sheriff ultimately lands on relevancy objection, reportedly because the examples that Mr. Bilbrey provide are from much larger municipalities, and the president of the United States, which the sheriff believes has a public relations office that are massive in scale, even ignoring the fact that Mr. Bilbrey only provided examples and did not purport to provide an exhaustive list. The sheriff does not explain what the size of the entity's public relations office has to do with anything. Maybe he has public relations office size issues. He's got public relations size envy. The point of Mr. Bilbrey's observation is that to him there is a clear distinction between viewing and commenting on posts made by an individual official and viewing and commenting on posts made by a faceless entity such as the sheriff's office, which I have long said. I have long held the fact that the City of Muncie Facebook page is the City of Muncie Facebook page, and we all know that like 4 or 5 different people respond as that. One of the people who almost hardly never responds, probably if ever, probably doesn't know how to, probably doesn't have access to, is Dan Ridenour. If I want to speak to Dan Ridenour or address him on Facebook, I am never going to go to the City of Muncie page. I would go to Dan Ridenour's Facebook page or Dan Ridenour, Mayor of Muncie page. Okay, so what he's saying here is, again, asinine. Finally, the sheriff objects to Bilbrey's statement that he recalls multiple instances where he was not able to view content on the page operated by the Henry County Sheriff's Office because that content has been shared from the Facebook page at issue in this litigation to the other. He reiterates this objection using slightly different language later in his brief. While the sheriff is correct that Mr. Bilbrey was only able to cite one concrete instance in which this occurred, now keep that in mind. I was only able to cite one concrete instance, okay? Look back up here. Look back up here at what Linke said. The attorney wrote it out in Linke. All right. The court, under Linke, the court must assess whether the sheriff has actual authority under the state law. The court must assess whether the sheriff had actual authority under state law to speak about the matters he routinely possesses to the page. The court's contention that he lacked actual authority to do so. Down here. Okay. in Linke, okay, right here, Mr. Bilbrey needs to only demonstrate that a single post constituted state action. Under Linke, I only need to show one post did it. Okay? That's what we did. So that is what we did. And they're objecting to the one thing the court says that we have to do. We cited one. I was only able to cite one. Okay? It is, after all, the sheriff, not Mr. Bilbrey, whose ability to remove posts from either page. This has nothing to do with the admissibility of Bilbrey's statement. Indeed, if witnesses were not able to testify as to matters they recalled, that this is to their own memory of pertinent events, countless legal actions would never get off the ground. Mr. Bilbrey's recollection regarding other instances in which the sheriff shared material between the two pages is quite plainly factual evidence based on his own personal knowledge. And given the sheriff's failure to offer any contrary evidence, it's undisputed. The sheriff didn't say Bilbrey is lying. He just questioned that I only gave one source. Well, I only need to give one source, first of all. But second of all, I can't prove a negative. If sheriff has deleted things that were originally posted, I can't prove that they were once there. I might have screenshots, but we went back through and we don't. I don't, sometimes I get lots of good screenshots. Sometimes I don't. Shit happens like that. The sheriff's elaboration on several facts previously articulated by Mr. Bilbrey does not create factual dispute, and he does not contend to the contrary. All right, folks, it's getting ready to get good. All right, you're getting ready to get into the comedy. The sheriff next appears to take issue with several facts recounted by Mr. Bilbrey in his earlier brief, although he does so under the rubric of material facts in dispute. At no point does he actually articulate any disputed facts. So keep that in mind. That's pretty big. Okay. First, the sheriff contends that Mr. Bilbrey incorrectly describes the sheriff's powers and duties as sheriff. All right. It appears he's attempting to make 2 points. Hold on here. Okay, let me come back to that because this is important. I'll come back to that point one. Given the sheriff's failure to offer any contrary evidence, it's indisputed. There's a 3 here. If we drop down here to this footnote, we see where it says later in the brief, the sheriff insists that even though Bilbrey may not view any posts that were shared from the Facebook page at the issue in the litigation of the Facebook page operated by the sheriff, he may nonetheless comment under the empty post. I'm not able to comment under the empty post. It does not give me that option. Even ignoring the absurdity of commenting on a message that reads, "This content isn't available right now," rather than on a content itself, this citation-free statement is simply wrong. The record reflects that Mr. Bilbrey is unable to view or comment on this post and on any comments that other users have left on the post. That's important for people to understand. The sheriff is trying to slide something in here, hoping the judge just might be old enough that he doesn't know how Facebook works, or might not be tech enough that he doesn't understand how Facebook works. Okay? And I'll be honest, I didn't know or think about this. It wasn't something that, even being like a younger person, I'm not a tech wizard. I didn't know this until we started looking into this. But because of the fact I'm blocked, it says I can see where it will say in a place like content was here, it's not available, but it doesn't let me contact there. Sheriff's like, well, he can comment under there. What if I'm commenting on something that says like, we're trying to return somebody's dog, and they did, And then because they returned it, they like blocked it or hid it or whatever. And I'm commenting something about, the sheriff's tax deal. I mean, obviously I would, if that's a possibility, I'd have a right to do it, but it's just stupid to comment when you don't know what the actual post is about. It just shows how out of touch and how stupid the sheriff and or his attorney appears to be. I honestly can't believe the attorney wrote some of this stuff. Going on, I have said that part of the sheriff's duties is fostering community engagement and trust with the community, speaking to constituents and community organizations. They're saying that that's not exclusive duty, okay, and that I'm wrong. I'm wrong in that assertion that that's what he does, okay. And so this is where my attorney is laying this out, that he has authority to make official announcement about activity of the sheriff's office, and that he has done so through separate Facebook pages maintained by the sheriff's office. Both of these points appear to be entirely consistent with Mr. Bilbrey's factual recitation, as well as with the Supreme Court's observation in Linkey, that a grant of state law authority over particular subject matter may reasonably encompass authority to speak about it officially. Next, the sheriff takes issue with the manner in which Bilbrey describes how the Facebook page at issue in this litigation appears to the public. Much of his discussion concerns with the operation of the page before he assumed office, and only serves to highlight the fact that once he assumed office, he made every effort to ensure that the page was a governmental page devoted explicitly to the activities of the county sheriff. By and large, none of the sheriff's historical description of the page is in dispute, and only one additional fact that he articulates requires response. The sheriff states that from March 8th, 2022 through July 12th, 2023, the bio section of his page identified him as a Republican candidate for Henry County Sheriff, along with the slogans professionalism, accountability, and transparency. This is meaningless, given that after he assumed office, the page loudly proclaimed that it belonged to John M. Sproles, the Henry County Sheriff. Regardless, the record citation offered by the sheriff is to a profile update history concerning the Facebook page that merely identifies this language having been added to his bio on March 8th, 2022. It does not follow the language remain there for the next 16 months. And third, the sheriff takes issue with Mr. Bilbrey's description of his post to the Facebook page at issue in the litigation. In his previous brief, Bilbrey acknowledged that several of Sheriff Sproles' posts to this Facebook page concern purely personal matters and provides several examples. The sheriff references to Bilbrey having mischaracterized the content of the page without support. Rather, given the Supreme Court's holding in Linkey that when a plaintiff blocked entirely from Facebook page, he need only demonstrate that an official engaged in state action with respect to any post on which he wished to comment. Mr. Bilbrey simply focused on the posts that matter, obviously. I am not going to post or talk about a post where the sheriff has taken a picture with his kids. I'm not going to post on that. I don't want to post on that. And I understand that as sheriff, he also is a human being, and I don't take issue with the sheriff posting a picture of his wife or his kids on a governmental page if he's like, hey, we, had a day out here, or wishing this is me wishing my son a happy birthday. I think that's perfectly fine. Elected officials are people, sometimes. I guess that's contrary to my belief. They're not people, but you get what I mean. I mean, I understand they're humans. You know what I mean? Maybe they're not people, but they are humans. Ultimately, the posts to the Facebook page at issue in this litigation appears in the record and are not disputed. The court may decide for itself what constitutes a personal post. Nonetheless, in the manner in which the sheriff offers only a string site to post that he believes to have concern his family, friends, religion, and personal activities, obscures the fact that he has included a personal post concerning his participation with other county sheriffs in events hosted in the Indiana Sheriff's Association. A post concerning his participation in uniform with several other employees of the sheriff's office in an event honoring local first responders. A post concerning a visit to the gym with other employees of the sheriff's office that he concludes by saying, "I love our HCSO team," and a post concerning a tour of his office that he gave to children. Despite the sheriff's criticism of Mr. Bilbrey's political commentary, this commentary is both fully protected by the First Amendment and largely irrelevant to this litigation. Here's, folks, where you might want to get ready to change your diaper, because here's where you're going to lose it. The sheriff next describes in some detail Mr. Bilbrey's public criticism of the sheriff. It is not remotely clear what he hopes to gain from this. I love that line. It is not remotely clear what he hopes to gain from this. I fully believe that he hopes that the judge will be like, "Oh, Mr. Bilbrey's a bad guy. He used words that aren't so nice," or he's a poo-poo head. You know what I mean? I think that's what he's trying to do. He's trying to dirty me in the eyes of the judge. And I think that the judge is too... He's
trying to victim shame.
Yeah, that's exactly what he's doing.
He's victim shaming.
Yeah, that's exactly. Mr. Bilbrey acknowledges that he is a vehement critic of the sheriff. I don't think that's I don't think that is lost on anybody. Has anybody ever heard me say anything different? I'm a vehement critic of the sheriff. I think he's a complete nut job. I often criticize the sheriff in caustic terms. I'm a caustic human, man. I've often said that there are two things that I believe completely ways of looking at me. I am either someone with nice, happy, sunshiny personality with asshole tendencies, or I'm an asshole with nice, sunshiny, happy tendencies. One of those two things. To me, they're two heads of the same coin. I have no problem calling a jackass. And I have no problem having a sharp tongue when it's required. And I don't hide the fact that I am a vehement critic of the sheriff and many other buffoons. And I criticize the sheriff and many others in caustic terms. The fact that he uses harsh language on his own podcast and act fully protected by the First Amendment is not clearly relevant, for it is undisputed that when he commented in the past on the Facebook page at issue in this litigation, his comments were critical but never threatening. I've never threatened the sheriff on his Facebook page. I've never threatened the sheriff on my show. Okay? While speaking to the sheriff via his Facebook page in his house, I've never been vulgar. I've never been profane or otherwise been inappropriate. I may have said, "You're no good, you're a weirdo, you suck," We want to beat you. We don't like you. I don't like you. I don't think you're good. You know, you're an FNG. I might have said those things, but I was never violent, threatening, crazily ill-tempered. I was never vulgar or profane or otherwise inappropriate. If I had been threatening, I could see the sheriff taking action. I wasn't. So the fact that he doesn't like the words I use on my show, maybe the sheriff shouldn't listen. Maybe the sheriff should wash his ears out with soap. Nonetheless, given the sheriff's recitation is worth underscoring, the harsh language employed by Mr. Bilbrey on his podcast is generally utilized to discuss issues of clear public import. For instance, his reference to the sheriff sitting around, probably rubbing his nipples in his very small uniform. So once again, this has made itself in to a public filing. I love that my attorney then breaks into this sentence. For instance, his reference to the sheriff sitting around, probably rubbing his nipples in his very small uniform. Interrupt. We can't all be Daniel Webster. Was in direct response to the sheriff's statement on Facebook page at issue in the litigation that he had never met Mr. Bilbrey in a statement that Mr. Bilbrey believes to have been an outright falsehood. Said Mr. Bilbrey immediately after the language quoted by the sheriff. It's really scary to hear you lay out statement such as this, to know that you write police reports and you're able to just lie so freely. You've never met me? You've never met me? That's complete horseshit. We have met multiple times. That's basically what I said at the time. As Kate has put over here in the comments, this is hilarious, not necessarily important, but it's amazingly funny that they've put this in here. So I want to actually really, really briefly, 106, I want to go back because it's 3 minutes, because I thought about doing this the other day and I didn't. And I guess we'll just do it with you guys all at the same time. Let's just go back really briefly and take a look at exactly what was said, so we will all fully have an understanding of what was said in that time. The attorney's broken it all down and made it very easy for us. We can find it, we can get it, and oh wow. Okay, this is what this is. I did not know this. Kate, what time is it on there? What time it does? Oh, you can't see, can you?
It's 31 through 3201.
31 through 3201.
I just have to enlarge my screen so I can really see really well.
Okay.
I mean, I can read it, but this is easier.
31.
The next part coming up is my favorite, with everybody in the comments who's been enjoying the versatility of the word cockwomble.
I know. Okay, here we go. Stop, present, share, watch, click. enlarge, view, share. All right, ladies and gentlemen, we're going to hear it in real time. He's in a pod, unfortunately. This is typical of them. Sometimes I think it's good for our citizens to see what kind of nonsense we get to deal with. Now, I have no clue what he's talking about. Hey, John, listen, because I know that you're listening, and I know that I know that your weirdo FNG senses are tingling, and you're sitting around probably rubbing your nipples in your very small uniform right now, off duty. Meaning that like he can sense that I'm talking about him. And so he's just sitting at home, because this is what I'm implying by this. That this guy's so weird. He doesn't act like a regular sheriff. He acts like a new guy. When you get a new officer, I guess I should have explained this back then. I'll explain it now. When you get a new officer who becomes a cop, and they go through this period where they want to work 24 hours a day, 7 days a week, 365 days a year. They always want to be on. They always want to be a part of it. They go home. They sit around in their uniform. They generally will put their uniform on early, and they'll go out and they'll jump calls, and they'll show up to calls. It's like, get out of here. Whatever. They just want everybody to see them in uniform, and it takes a while to break them out of that habit and get them into thinking like a normal human. Like, don't tell everybody you're a cop. Relax, calm down. You're going to get in on the excitement. Just shut up. Sproles is still like that. Very, very much like that. He's very much a person who is like, out there, and he wants to be seen, whatever. And so a lot of these FNGs, what they'll do is they'll get scanners and they'll sit around and they will listen to their agency's calls so they can just be on it. Well, Sproles does that very same thing. And so that's what I am relating to here when I'm saying that, he's just so ready to go that he's excited all the time. So that's what I am referring to here in a rather caustic, unpleasant way. I'm being a smartass, just talking about how he's not just because he's not had a 20-year career and he's now the sheriff. He became sheriff when he's still in it. This is like a new guy becoming the sheriff. That's why that's not really supposed to happen. So let's go on here. You think that you've done something here, but I think that it's really scary to hear you lay out a statement such as this, to know that you write police reports and you're able to just lie so freely. You've never met me. We've never met. Sir, I started contacting you, and you and I started talking as early as April of last year when you were running for office, and we've had multiple phone conversations where you and I had more than friendly phone conversations and got on just fine. It wasn't until you went after your opponent in October, and I realized what a very scary candidate you were, and realized how fearful that made me, thinking that you could possibly become the sheriff of Henry County, that I started looking into you. I wasn't going about my life and thinking, I'm going to start spending all my time communicating on Sproles. This is what I do for a living. And you just happen to be one of the ass clowns that walks your way in front of my my magnifying glass. And so that's what that is. And he's had so much about this. Stumblefoot. So this is what he has done. He's so nuts. But he was the Caddis Town Marshal for a little over a year. Yeah, absolutely. But I don't even like. I will be polite even to reserves. Reserves get have People get good training and experience, and that it's easy. Sproles, in all of his time, you can put all of his time together back when he was a young man, and he did it for a little bit. And all of the guys hated him back then, because when he first got on back then, he would jump calls over into Newcastle, and he'd go running through town. He was just like everybody, but he's just got that lifelong FNG syndrome that's in him. And it's those people. I still say John Sproles, if he would have been in any other city, in any other county, John Sproles would have been washed out in the field training officer, the FTO period. He should have probably been washed out at the academy. He just barely made it. Good for him. If he was anyplace else, that he would have been washed out. And unfortunately, he wasn't. And the people of Henry County have to deal with him. And he's an elected official that does dumb shit. So now I have to deal with him. And it is what it is. It's no good. Okay. All right. Moving on here. We're almost done. Okay. You guys can see that. So, all right. Here's the next part. Mr. Bilbrey's reference to the Sheriff Sproles as a cockwomble. This is what my attorney writes. Was part of a short word of the day video that defined the term as a person prone to making outrageously stupid statements and or inappropriate behavior whilst having a high opinion of their own wisdom and importance. I love that he wrote that. I love that this is now part of the record. Oh my God, this is amazing. Wow. And then, of course, he comes back here and he says the most important part of this. Every individual, of course, is allowed, entitled, permitted, okayed to express such opinions about his or her elected officials. And man, isn't that what makes this country beautiful? It's amazing. It's absolutely amazing. Mr. Bilbrey's publication of the personal creed of the sheriff's office. Remember that personal creed, which he advertised as a satirical look at a document that the sheriff put out for all of his employees. It highlighted many of the controversies that have arisen since the sheriff has assumed office. For instance, Mr. Bilbrey referred to the sheriff as John Beanbag Sproles. That resulted from a controversial incident in which the sheriff himself deployed less lethal beanbag rounds against an jail inmate locked in an isolation cell. That man happened to be a black man. Just keep that in mind. To anyone familiar with newsworthy events in and around Henry County, Mr. Bilbrey's satirical reference to Sheriff Sproles' belief that all white Christian people are created equal by the Almighty. That obviously would bring to mind both the baptism day at the Henry County Jail, which was what Sproles called an event, and a troubling episode in which the sheriff suspected a Milwaukee dance troupe comprised largely, if not entirely, of black individuals whose bus had broke down near I-70 of being a human trafficking operation. Okay, that's very, very important. That's just very important to understand that all of those things together, in my opinion, make Sproles a laughable joke of a human being, of an individual, of an elected official. And we must hold these people accountable, hold them up to the light, point out the absurdities, and run them from office as fast as we can. And that's the point of all of this. All right.
Well, it's also interesting that he mentions these in here, because don't those cases both involve torts?
Yeah, absolutely. Yes. Yeah, in which the sheriff and or the sheriff's department is being sued because of various actions in those situations. Yeah, absolutely. The point, of course, is not whether either the sheriff's actions or Mr. Bilbrey's criticisms of those actions are right or wrong. The point is that the First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on our government public officials. That's very, very important. Mr. Bilbrey's political commentary fits squarely within this tradition, and the sheriff's decision to underscore this commentary is curious. And then there's a little 6 by it. Following the incident in which the sheriff suspected a dance troupe of being a human trafficking operation, Bilbrey shared both a recorded statement in which the sheriff accused a law enforcement officer from another agency who also happened to be black of simply being there to protect, quote unquote, his people, and a statement from a local elected official referring to the sheriff as a racist son of a bitch. After that recording and at the end of that video, I said, I don't know, ladies and gentlemen. You have to make the determination on your own. This is where I'll leave it. You let me know what your thoughts are. I didn't make the call. I'm just giving you guys the information and hoping that you make the right call with it. That's what I said. And I don't think at the end of all of this, the sheriff realizes how bad it makes him look in this First Amendment rights lawsuit. He is bitching about my First Amendment right. Like, that's nuts. Okay, moving on from there, to the extent that the sheriff highlights that his commentary is an attempt to contend that Bilbrey has not been adversely impacted by being blocked. So he's saying, like, he hasn't hurt me. I can still give commentary and do this or that. The fact that he was able to continue discussing an elected official when the official's actions became public through other sources says nothing about the impact of not being able to view information disseminated by the sheriff on Facebook page at issue in this litigation. If possible, it says even less about Mr. Bilbrey's desire to participate in discussions in Facebook comment section. Okay, that's important to keep in mind. All right, we'll come on down here. Okay. What the court did not ask was whether the official also played a role in operating a separate government account. All right. And what they're talking about here is the sheriff begins his statement of undisputed facts with a description of operation of a separate Facebook account maintained by the sheriff's office. All right. So it's important for this section for you to know that the sheriff's saying, I can do that because I have 2 pages. You know, I've got this other page over here. This is good. This is so for good reason. And this is so for good reason that the court didn't ask if there was a separate governmental account. Only under the rarest of circumstances does the First Amendment tolerate content or viewpoint-based censorship anywhere. And the existence of a potential alternate channel for communication is only relevant when a government official has imposed a content-neutral regulation of speech that is narrowly tailored to serve a significant government interest. Okay? The sheriff's focus on the separate page maintained by the sheriff's office also ignores the undisputed facts of this case, demonstrating that Mr. Bilbrey's ability to view and comment on that page is not adequately an alternative to accessing the page at issue in this litigation. For one, while occasionally posts are shared between the 2 pages, the content of the 2 pages is not identical. and even when similar posts are made to both pages, the conversation in the comments section of the post may differ dramatically. Additionally, unlike posts made to the Facebook page at issue this litigation, posts made to the separate page operated by the sheriff's office seldom, if ever, appear in Bilbrey's news feed, throughout which he views and comments on material through Facebook. Now, I could take the extra work and do the extra thing and go about getting that, and I have it, and I look in it, but I should not be barred from this whole other section where the sheriff does the majority of his work at. Look, I can set up, I set up a Facebook page. I've got 2 Facebook pages. I've got my Facebook page, Kristopher Bilbrey, and then I have my Facebook page, we have the Political Spotlight. Now, more and more people are joining the Political Spotlight, and I share shit there. I share shit. Anytime I share on my page, I always share it to the other page. But more people interact with me on my main page, and that's the page that I use as the main page for the podcast. I don't use it as a personal page. And if you go and you look at the 2, there are more people that interact on my main page than the actual page for the actual title. One of the pages is Kristopher Bilbrey, and then down below it says political commentator, and then in the intro it says the Political Spotlight, and it has the YouTube link and the Fireside link. Then there's a Facebook page that is the Political Spotlight. When I direct people to my Facebook page, I direct them to both, but I direct them to the Kristopher Bilbrey page first. That's no different than what the sheriff is doing. He's just doing it backwards. He's not allowing me to have access to the page where the majority of the people are at. Okay. Moreover, as noted above, to Mr. Bilbrey, there is a clear distinction between viewing and commenting on posts made by an individual official and viewing and commenting on posts made by the faceless entity such as the sheriff's office. When he comments on posts made by the individual such as the sheriff, he perceives himself to be interacting directly with the official such that he is able to hold that official accountable or attempt to do so for his actions, policies, and statements, and for acting in a professional and transparent fashion. On the other hand, when he interacts with the entity such as the sheriff's office, it does not engender the same level of personal accountability. Presumably because of this distinction, Mr. Bilbrey is aware that it is not uncommon for an elected official and the institution that he or she represents to operate separate governmental Facebook pages. This is the whole issue that we're having in the city of Muncie right now. And that's why I think that this lawsuit is so important. This lawsuit will have implications far-reaching outside of Henry County. Very, very important. All right? To be sure that, as the sheriff notes, on isolated occasions, Bilbrey has exercised his First Amendment rights to comment on the separate Facebook page operated by the sheriff's office. The sheriff's citationless reference to him doing so on a daily basis, however, appears to be rhetorical hyperbole. Appears to be rhetorical hyperbole, and that is not supported by the record. Rather, the sheriff has cited comments that Mr. Bilbrey made to only 2 Facebook posts in nearly 8 months apart, one from July of 2023 and the others from March 15th, 2024. Although Mr. Bilbrey made multiple comments to each of these 3 posts, nothing in the sheriff's factual recitation contravenes Mr. Bilbrey's description of the inadequacy of the alternative of the sheriff that the sheriff offers. All right, that's important. Moving on down here, okay, they go through the different times that the sheriff has changed his names. Of importance, while the sheriff maintains that the page has at all times served as the Facebook page of his political campaign, he has used the page continuously since assuming office, even though there existed a period of time that he had not even decided that he would seek re-election. Rather, there could not have been a political page, such that there could not have been a political page. Even though at the time of his deposition in April of 2024, he still had not announced his intentions to seek re-election. And even though the next election was years in the future, he's going ahead and calling this a page. The sheriff utilizes Facebook page at issue in this litigation not as a separate sheriff's office page to engage in some communications that he admits to being governmental, such as soliciting artwork that he might use for the sheriff's office logo, seeking a contract to obtain trophies for retiring officers, reviewing safety tips to be disseminated by the Henry County Farm Bureau, communicating with constituents about a nuisance complaint, and addressing an inquiry related to a commissary money of an inmate of the Henry County Jail. This is all happening on his main page, which he's blocked me from. Look, I'm calling it his main page, and he's calling it a campaign page. I don't know any other elected officials that would do that in that manner. That's strange that he's intermixing those two the way that he does. Consistent with all of this, since he has assumed office, the overwhelmingly majority of the sheriff's posts to the page at issue in this litigation have concerned the activities, the prerogatives of the sheriff's office. Indeed, multiple posts have been signed John M. Sproles, Henry County Sheriff. And not until he blocked Mr. Bilbrey from accessing that page did the sheriff append to the page a disclaimer indicating this is not an official page. That was not there. That was not there until he blocked me, and he quickly found out, we're probably in trouble. Against all of this, the sheriff describes as an undisputed fact his belief that the page at issue in this litigation represents a place where he can promote himself by expressing his personal feelings and opinions about various matters, including matters related to the sheriff's office. Wow. Who would have thought? This broad statement is not supported by the record, far from discussing his use of the page in general. The deposition testimony on which the sheriff relies for his statement concerns 3 discrete issues. All right. None of this, of course, creates a factual dispute for summary judgment. This court must look beyond any misstatements, and instead see the record for what it is. Okay? That is important. The record is what the record is, period. It doesn't, that's the most important aspect. The only citations offered for these statements are 2 specific posts made to the page. These posts speak for themselves. The sheriff's description of the post as addressing personal opinions and personal thoughts appears to be his attorney's elaboration that is unsupported by the record. After all, simply because post contains opinions and thoughts does not mean that they are personal, for even a governmental entity has a right to speak for itself and is entitled to say what it wishes, to select the views, and to select the views that it wants to express. Indeed, among the posts cited by the sheriff in support of these broad statements are multiple posts that he specifically signed John M. Sproles, Henry County Sheriff. I don't know that I've ever seen him, since he's been elected, sign as a candidate running for re-election. He does not do that. That does not fit with his brand. He's the sheriff, even his father-in-law, on his dying bed, the sheriff made sure to let us know that he was telling this man, I am your sheriff. Sproles carries it very bizarrely. He makes mention of that. That's how he sees himself. That's his brand. Similarly, After describing in detail only 3 posts to the page at issue in this litigation, Sheriff Sproles concludes without citation that these 3 posts are typical of the remaining posts to the page. That's not true. Argument. Sheriff Sproles' operation of the Facebook page at issue in this litigation and his blocking of Mr. Bilbrey from the page constitute state action for which he may be held liable. Okay? And this is pretty clear. At all times since assuming office, the sheriff has possessed the actual authority to speak on behalf of the Henry County Sheriff's Office with respect to the issues about which he routinely posts on the Facebook page at issue in this litigation. The sheriff utilizes the Facebook page at issue in this litigation and disseminates press releases issued by the sheriff's office to manage the sheriff's office personnel and to share personnel-related information, and to detail a broad array of day-to-day activities of the sheriff's office. It should be noted, it should not be open to dispute that he possesses actual authority to speak on behalf of the sheriff's office with respect to these issues. He acknowledged as much in his deposition. Okay? He said he did. Nonetheless, the sheriff contends that because none of the sources previously cited by Bilbrey specifically authorize him to issue public statements on social media, the first prong of Linkey test is not met. That is not true. Curiously, while he makes this broad pronouncement with respect to the Facebook page at issue in this litigation, a pronouncement like that under the best of circumstances represents hopelessly narrow interpretation of Linkey in the state action requirement that would place a virtually insurmountable hurdle in the way of any plaintiff. He acknowledges that he does have a state law authority to issue statements through a separate Facebook page operated by the sheriff's office. Despite the sheriff's contention to the contrary, Linkey makes clear that the proper inquiry is not whether he has authority to issue public statements on social media, but it is certainly not whether he has authority to issue statements on a specific social media page, but whether he has authority to issue public statements about activities of his office in general. Okay? That's important. That's very important. It did not hold that the defendant must be authorized to speak for the city, specifically on social media, but instead held that he must be empowered to make the official announcements. They're talking about Linkey there, all right? Indeed, it would be an odd state of affairs if a plaintiff required to demonstrate that a state law which may have been enacted long before the advent of computers, let alone social media, envisioned an official's use of particular social media account. At best, the sheriff's contention that he lacks state law authority to post about activities of his office on Facebook at issue in this litigation conflates the misuse of authority with the absence of authority. Okay? That's important. At worst, this contention is hopelessly contradictory. The sheriff acknowledges that he possesses actual authority under state law to operate the latter page. He also acknowledges that in his governmental capacity, he routinely issues press releases concerning the sheriff's office initiatives and activities, and that discusses the prerogative of the sheriff's office with the media on local podcasts and community events. The sheriff does this. He has done this. He's spoken on my show before. He even acknowledges that he has utilized Facebook page at issue in this litigation to make official inquiries on behalf of the sheriff's office, such as soliciting artwork for use in a logo and trophies for retiring officers. What exactly does the sheriff think distinguishes the state law authority to make any of these statements from his state law authority to post about similar matters on Facebook page at issue in this litigation. In the end, he offers only his own. He said it. In the end, he offers only his own. He said it himself, which quite plainly is not enough, despite his.
It's Steve Dixit.
Yeah.
Which, but it's the toddler's argument because
right
because I want it that way.
Because I want it. Right.
Or a parent saying because I said so.
So he outlined that in his saying he's the one he outlined that this is not our attorney saying this. He outlined it. That's what he's saying right here. Okay.
Yeah.
Despite
he outlines this. He says, I have authority on this page to make statements, but this one, no, I don't have authority on that one to say anything.
Which is stupid.
Even though I've used it to say things.
Which I've done that. I've done it on both.
It's the
mindless.
Yeah, it's contradictory and mindless and a toddler's argument.
Which does not make sense to me because I want to be really clear in these documents. The sheriff is not sitting down writing this out. His attorney is. And his attorney's questioning him and going back and forth. And they do that. The same thing with mine. The attorney is writing this for me and we're going back and forth. And it's my statement written through the attorney with the attorney's legal jargon and laying it out for the court. And it's like that. So my question to this is, why in the hell would his attorney allow him? Like, it floors me in what's actually going on here.
Well, I mean, we pointed out that there was a contradiction in his statement because he says, I have authority to do it here, but I don't have authority to do it here, but I have authority to do it everywhere else.
Yeah, right. Yeah, I have no idea. I'm so shocked that the attorney is saying, yeah, this is a good argument. This is an argument that we should be making. I think they don't care and they're hoping to get out of this thing as cheaply as humanly possible. Right.
That's my personal opinion.
Right.
They're just trying to get out of it as cheap as they can.
Yeah. Despite his insistence to the contrary, he has actual authority to make public statements through social media and elsewhere about activities, prerogatives of his office. The first prong of Linke is met. It has been met. It doesn't matter what weirdness the sheriff says. It's met, period. That's what it is, okay? We're almost done here, folks. Bear with me. We are almost done. The sheriff purports to exercise his government authority through the Facebook page at issue in this litigation. The issue then is whether the sheriff employs the Facebook page at issue in this litigation to speak in his official capacity or to fulfill his responsibilities pursuant to state law. As Linke makes clear, when an individual is blocked entirely from a social media page, he must demonstrate only that an official purported to exercise his government authority with respect to a single post on which he wishes to comment. Done. Okay? When it comes to Freed's wholesale blocking of Linke from accessing the page, Linke needed to only identify one post in Freed's account that represented state action. Decision remand. That is not a difficult showing here. Despite the sheriff's contention to the contrary, for several reasons, the facts of this litigation demonstrate this. On the second prong, Linke is also met. By blocking Mr. Bilbrey from the Facebook page at issue, it is in this litigation, the sheriff has prevented him from viewing or commenting on some post made directly to separate sheriff's office page through which he acknowledges he exercises the official authority. Ding, 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 ding. As described in both Mr. Bilbrey's initial brief and above, from time to time, the sheriff shares posts to the sheriff's office page that were originally made to the page at issue in the litigation. Because Mr. Bilbrey is blocked from the page at issue in the litigation, he is thus unable to view or comment on the post, even though it is shared to the sheriff's official page. So while I haven't even actually looked at it like this, he's blocked me from commenting on one page, and he's blocked me from commenting on what even the sheriff considers as official action on the sheriff's office page. So he's technically got me screwed in two ways. That's really good of the attorney. This case, where the sheriff is the highest ranking official in the office and where he acknowledges his own authority to speak publicly about the activities of the office, does not exist in any sort of a gray area. That's important. Then he shows us, instead, because Mr. Bilbrey is blocked from the page, instead he is greeted with this image. This is the image I'm greeted with. And you see where it shows me there are 9 comments. Sometimes I can see the comments, sometimes I can't. It shows me there's 1 share, but it does not give me the ability to like and or to comment. It simply shows me this. While he is unable to do so, Mr. Bilbrey's desires to comment on this post and on any comment or any other users have left on this post. Okay? While I am unable to do so, Mr. Bilbrey desires to comment on the post or any other the other commenters are, and I can't. The sheriff's only response to this is to say that it is an innocuous posting from a campaign page to a governmental page does not give rise to a violation of the Hatch Act. There are many things wrong with this argument. First, and most notably, Linkey is clear that when an individual is blocked entirely from a social media page, state action need only exist with respect to a single post. Whether the sheriff believes that posts to have been innocuous or not, and as detailed above, it is undisputed that the sheriff has shared posts from the page at issue in this litigation to the sheriff's office page on more than one occasion. This is enough. Linkey lays that out. Linkey requires that state action exists only with respect to a single post. And this is a post for which everyone agrees that state action exists. The sheriff agrees, I agree. The sheriff ignores this rudimentary fact. Second, this is simply not a Hatch Act case. While Bilbrey previously underscored the sheriff's obligations under that statute in explaining why, despite his insistence to the contrary, the page at issue in this litigation cannot be bona fide campaign page. This argument is altogether distinct from the argument that the sheriff's actions have prevented him from accessing or commenting on government posts made to the sheriff's office page. Okay, it's very, very clear here that he can't be doing both. He does not think that it's a Hatch Act issue, but it is. He's just wrong here. All right, going on. The distinction is ignored by the sheriff. Third, did I read that part? The actions have prevented him from accessing or commenting on the government posts made by the sheriff. This distinction is ignored by the sheriff. And third, even were it accurate to describe any Facebook post as innocuous, there is no, what is this, de minimis exception to the Hatch Act, which is means pertaining to minimal things. It is used in the legal system to refer to certain facts or issues that are so minor as to be undeserving of the court's attention. Okay. By blocking Mr. Bilbrey from the page at issue in this litigation, the sheriff has prevented him from viewing or commenting on some post made to the sheriff's office page. That is all that Linkey requires and should be the end of this case. Before The sheriff added the disclaimer to the page. He changed the name of the page in July and then in October. There were no ambiguity with respect to whether he has exercised governmental authority through the pages. Next, Linkey explains how to determine whether an ambiguous page is governmental or personal. It's very easy. After all, the disclaimer is established a heavy, though not irrebuttable, presumption that all of the posts on the page were personal. For the first 6.5 months of his term, and at the time the sheriff blocked Mr. Bilbrey from the Facebook page, the presumption simply did not exist. As explained previously, before the sheriff attempted immediately after blocking Mr. Bilbrey from that page, and ultimately without success, to rid his Facebook page of its government, to make it the government page, there was nothing more ambiguous about the use of the page. It's so stupid that the sheriff thought that. This is like the covering up the after the crime, and it makes it so much worse. First and most importantly, upon assuming office of sheriff, he retitled the page from John M. Sproles for Henry County Sheriff to John M. Sproles, Henry County Sheriff. Period. Again, he can't make it any more clear. And until he got in hot water, this is what he wanted to be known as, because this is his legacy. This is who he is. It's his brand. Far from inconsequential, this is the sheriff himself informing persons that the page no longer belongs to his campaign, but instead it belongs to the elected sheriff, the elected official. All right, that's important. Second, by his own admission, after assuming the office, the sheriff utilized the Facebook page at issue in this litigation and not the separate sheriff's office page to engage in communication that he admits to having been governmental, ranging from assisting constituents with nuisance complaints, safety tips, soliciting artwork for use of the sheriff's office, and much more. He cannot maintain simultaneously, as he attempts to do, that he utilizes the Facebook page to perform government functions and that the page has nothing to do with the government. That's insane. Suffice it to say that the sheriff's reference to the permanent campaign presupposes that an incumbent who has resolved to seek re-election. The record simply does not support that assertion that the sheriff began engaging in campaign-related activities. Really, honestly, he can't. There's nothing that he could have done. That's stupid. From the moment that he assumed office, look, it's quite frequent that people who run for and win office at least assume they're going to run again. But you don't immediately jump into campaign mode on January 2nd. That just does not happen. Even when he was asked during his deposition by his own attorney why he posted certain material to the page at issue in this litigation, he did not mention, even tangentially, a need to engage in campaign-related activities. This court need not to turn a blind eye either to the reality that his use of the page was far removed, both temporarily and in content, from the 2026 election, or to the fact that the sheriff is unable to point to a single other step that he has taken towards seeking re-election. He still hasn't. Here it is. John M. Sproles, Henry County Sheriff. John M. Sproles, Henry County Sheriff. Clear as a bell. Clear as crystal. Facebook page at issue in this litigation remained governmental page even after the sheriff added a disclaimer indicating that it's not an official page. Of course, the sheriff's addition of this disclaimer to his Facebook page immediately after blocking Mr. Bilbrey from the page served to establish a rebuttal presumption that posts after that point did not constitute state action. In addition to the curious timing of the disclaimer, added more than 6 months after the sheriff assumed office and promptly after blocking Mr. Bilbrey from the page, the sheriff continued to call the page John M. Sproles, Henry County Sheriff, for another 3 months. Even after adding the disclaimer, by his own admission, the sheriff continued to utilize the page to perform his official responsibilities. Many of his posts to the page, for instance, those soliciting applications for position within the sheriff's office, cannot reasonably be justified as serving campaign-related purpose. The sheriff largely ignores these points. Well, of course he does. In so doing so, he does not dispute that he routinely posts to his page while on duty. As indicated previously, not only does he do so in the middle of weekdays, but he often does so within minutes of posting similar or identical content to the other page. Nor does the sheriff dispute that when he were an hourly employee, use of government time to post on Facebook page would be indistinguishable from use of government staff to do so, which Linke says would almost certainly necessitate a conclusion that an official was purporting to exercise state authority. He nonetheless insists, however, that the same principle does not apply to him insofar as he is now salaried. This simply makes no sense. While a salaried employee might have a greater flexibility than an hourly employee regarding when he is on duty, in an official who posts to Facebook about activities of his office during those periods of times, whatever they may be, will be hard-pressed to deny that he was conducting government business. Linke leaves no room for such arrangement. Early in his brief, the sheriff does contend that many, but by no means all, posts to the page at issue in this litigation were made during times when he might presumably be at lunch or at home from work. He does not revisit this contention, which appears to be inconsistent with his subsequent characterization of himself as always on duty. In the argument section of his brief, his statements that he would often switch between being on duty and off duty depending on the circumstances is not supported by the record. Rather, in the cited excerpt from his own deposition, he testifies as follows. I assume there's a potential of unanticipated time when you will suddenly switch from off duty to on duty. Yes, Sproles said. If you see a crime being committed while you are grocery shopping, you will throw your sheriff's hat on at a moment's notice. Is that fair? Yes. If needed, that is fair. Yes. This testimony, of course, does not support the illogical reference that he might cycle between being on duty and off duty simply by virtue of the fact that he was posting to a page at the issue in this litigation. It's like he's sitting in his easy boy at home, flipping through Facebook, and he's like, I'm sheriff now. Now I'm not. Now I'm sheriff. Now I'm not. That's just nuts. Not satisfied with this, the sheriff likens Mr. Bilbrey's argument to a contention that a judge interacting with a minor daughter or an official receiving a personal phone call would be engaged in state action merely because these acts were done in a temporal proximity to the performance of government service. This hyperbolic comparison ignores the question that Linke instructs this court to answer, whether an official possessed actual state authority to take action and whether he or she purportedly exercised that authority in doing so. Suffice it to say, a judge's authority to instruct his or her daughter to go to bed derives from a natural consequence of parenthood, not from state law. But here the sheriff was not having a personal conversation. He was providing information about activities and prerogatives of the sheriff's office. He routinely does so while on duty for that office. Engaging in governmental sanctioned activity while actually working for the government is quintessential state action, and the sheriff's argument that the contrary is off base. Finally, the sheriff responds to Mr. Bilbrey's contention that he released the footage from a body-worn camera constitute exclusively government function. Indiana law vests the sheriff's office itself, not a political candidate, with the discretion to determine whether to release law enforcement recordings. The sheriff's reference to the footage captioned "a day in the life of being a sheriff" as somehow unrelated to official law enforcement function is both plainly incorrect and ultimately irrelevant. All right. It is ultimately irrelevant because the definition of a law enforcement recording includes any footage captured by a camera or other device that is designed to be worn by a law enforcement officer. Okay. The sheriff is therefore left likening the video of footage taken from a personal cell phone, liking the video to footage taken from a personal cell phone. That is not true. But they were taken from a body-worn camera, not a personal phone. And under Indiana law, the authority to release such footage belongs exclusively to the sheriff's office and not to candidate running for office. All the sheriff is saying is that the release of the footage that does not qualify as a law enforcement recording might not implicate his state law authority. Here, given that the footage undeniably does qualify as a law enforcement recording, the fact that the sheriff's office chose to link the body-worn camera directly to officer's cell phone to assist them in subsequently uploading footage to server maintained by the sheriff's office is obviously inconsequential. Apparently recognizing that the decision to release such footage belongs exclusively to the sheriff's office and certainly not to a political campaign, the sheriff ultimately left to characterize the episode as an isolated incident. This gets him nowhere. Once again, Linkey makes clear that when an individual is blocked from social media page entirely, he only needs to demonstrate that an official engaged in state action with respect to any post which he wished to comment. It is undisputed that Mr. Bilbrey, who the sheriff specifically referenced in this series of posts, wished to comment on the post. And under Linkey, this isolated incident is therefore enough. Even after appending the disclaimer to the Facebook page at issue in the litigation, the sheriff has continued to exercise his government authority through the page. For this reason, too, the state action requirement is met. Insofar, the sheriff's administration of the Facebook page at issue in this litigation constitutes state action, and blocking Mr. Bilbrey violates the First Amendment. Finally, the sheriff's office contends briefly that even if his operation of the Facebook page at issue in the litigation constitutes state action of the blocking of Mr. Bilbrey does not violate the First Amendment. That's insane. This is so, the argument goes, because the time, place, and manner analysis frequently applicable to speech restrictions in a public forum requires that an evaluation of whether the speaker has ample alternative channels for communication, and the sheriff contends Mr. Bilbrey may communicate his opinions in other manners. It should not require citation to demonstrate that the sheriff's argument is erroneous. For the censorship of an individual because that individual criticized the government official is quite plainly the antithema to the First Amendment. There is numerous flaws in the sheriff's argument, each of which is independently sufficient to reject the argument. First, there is a distinction between prior restraint on speech, time and place and manner restrictions, and the test articulated by Sheriff Sproles is not applicable here. When the government denies use of forum in advance of actual expression, it has imposed prior restraint on speech subject to strict scrutiny. This is a classic prior restraint subject to strict scrutiny, and the Sheriff Sproles advances no argument, nor could he, that his actions satisfy the standard. Second, even under time, place, and manner analysis, the test articulated by the sheriff is only applicable to speech restrictions that are justified without reference to the contents of the related speech. Any restriction based on the content of the speech must satisfy strict scrutiny. For the government to the government must abstain from regulating speech when the specific motivating ideology or the opinion of perspective of the speaker is the rationale for the restriction. Viewpoint discrimination, where the government targets not subject matter but particular views taken by the speaker on subject, is egregious form of content discrimination. Here, the sheriff blocked Bilbrey from following a particularly critical comment in which Bilbrey took issue with the misappropriation of a video concerning a controversial directive that had been issued by the sheriff. Whether viewed as content discrimination, viewpoint discrimination, or discrimination based on the identity of the speaker, the action is subject to strict scrutiny. The sheriff ignores this. Third, the sheriff appears to be under the impression that even where time, place, and manner analysis is applicable, he may prevail if he can demonstrate either the blocking of Bilbrey was narrowly tailored to serve a significant government interest, or that the actions of Bilbrey left ample alternative channels for communication. A speech restriction must be narrowly tailored to serve a significant government interest and leave open ample alternative channels for communication of the information. The sheriff's failure to contend that by blocking Bilbrey is narrowly tailored to serve significant government interest. Indeed, his failure to even articulate a government interest is fatal to his argument in this action, comports with the First Amendment. And finally, even putting all of this to the side, the sheriff's arguments ignore both the facts of this case and the government's limited role in dictating how individuals may exercise their speech rights. In other words, the sheriff is willing to allow Bilbrey to criticize some of his statements. On top of this, even where similar posts are made to both pages, there are sound reasons to post separate pages maintained by the sheriff seldom appear in Mr. Bilbrey's newsfeed. On Facebook, and Mr. Bilbrey perceives a distinction between commenting on posts made by an individual official on the post made by a faceless entity such as the sheriff's office. Mr. Bilbrey desires access to the page at issue in this litigation. The First Amendment mandates that we presume that speakers, not the government, know what's best for they want to say and what and how they want to say it. Mr. Bilbrey is entitled to judgment on the liability to permanent injunction requiring that he is promptly unblocked from Facebook page at issue in this litigation. And thus saith my attorney and I. There we go. Ladies and gentlemen, that was a lot to read. I cannot believe I've been talking for that long, and that was absolutely insane. It is very, very crazy, and I am interested in your all's thoughts. I know that we've been going for a while. I know it's almost midnight. I know some people had to bow out. I know that they will pick up back in the morning or tomorrow, and that's the reason I wanted to get through everything rather than making this a two-parter, plus we have a show we're going to do tomorrow. So when you watch this, whether it's now or tomorrow, I am interested in what your thoughts are on this. I'm interested in whether or not you think the sheriff and or his team are going to reply to this. Will they leave this stand and they leave their argument what it is? Will they reply within 14 days? From there, do you think that the judge makes a ruling based on our arguments versus his arguments? Or do you think the judge makes us march closer to going to trial? I'm fine with either one. I would like the judge to rule in our favor and rule that Sproles is a dipshit and all of our wildest dreams come true and all of us be unblocked. I'm also fine to go to court and face this guy in court. Either one is fine with me. So I guess we will see what happens. I will leave it there. You guys have been fantastic. Thank you for hanging with us, specifically the people who have stood by. Yeah, answer Kate's questions if you can, too. Does the sheriff stand a snowball's chance in hell of winning? Will the sheriff's lawyer reply to this? Will the judge give summary judgment? If so, in whose favor? And I guess lastly, I'll say, what do you want to see? Do you want to see a judgment summary, or do you want to see us go duke it out in court? Let us know in the comments. You can leave it in the comment section there. You can comment down below. I'm going to go shut up for a little bit. You guys have a wonderful evening. God bless each and every one of you. Take care. Have a great day. Have a great Thursday. We will cover tomorrow, just briefly, the Board of Works meeting from today. We didn't go over our guesses last night. I'm going to write that down, and we're going to start doing that, going over, how long the City of Muncie Board of Works meetings are and how much they spend. We need to start doing that every Tuesday. Maybe we can do that at the beginning of the week. Just kind of get through those. I will tell you, just briefly, the mayor did a 3-minute community update today with the animal shelter guy, Josh Talby. Oh, I think I win. Last night, I'm pretty sure that I said that the Board of Works meeting would be done within 7 minutes and I'm going to have to go back and look. I think I guessed last night on the dot 7 minutes and 38 seconds. And that is exactly how long the freaking time is. I think I win. I think I said that to the T. The meeting I just looked was 7 minutes and 38 seconds. That's hilarious. All right, you guys take care. Have a great Thursday. We will see you back here tomorrow. Good night. I'm going to shut up. God bless. Good night.
My 6th time through that thing, and I still chuckle. I'm not sure what point the sheriff is trying to make, but
I can't believe that I just read all that shit. I mean, even reading just the highlighted portions was still a lot.
You do have a tendency to get a little chatty from time to time.
Well, but that, I've talked about the specific issues, but holy crap. I mean, if you take out any of the pauses from the first, from the first 20 minutes of the episode, that was great talking for like nearly 2 hours.